Good afternoon, everybody. Again, my name is Carrie Nicholson. And happy Wednesday, happy fall. I don't know about all of you, but I certainly love this beautiful time of year. We are so thankful and very fortunate to have two awesome attorneys joining us today. Both of them will be facilitating the webinar. All of you may know and recognize Leigh Schultz. She is an employment law attorney specializing in labor-related issues. And then Gary Glenn, his area of expertise is taxes, which we are also very grateful for because for many of us, that's probably over our heads. So Leigh's going to kick things off and then Gary's going to wrap it up with his portion. So I'm going to go ahead and turn it over to Leigh. Take it away.
Thanks, Carrie, and thanks, Susan. All right, everybody. Well, it's nice to be here today. I'm sorry I can't see your faces. I know a lot of you that are out there are friends and clients of mine, so I appreciate you all coming. And I'm hoping my internet doesn't lock up. If it does, I'll do my best to jump right back on. Okay, so we're going to talk today about COVID. I'm sure it's everyone's favorite topic right now. It's all everyone's thinking about right now, and you've probably heard a lot of seminars and webinars and read a lot of material about it already. Some of this will be probably refresher and repeat of what you've heard before. Some of it will be new because we have some new executive orders that were just issued last week. So as Carrie said, please do feel free to ask questions in the Q&A function, and we'll do our best to answer them at the end. So what are we going to be talking about today, and what is it important that you're paying attention to? You want to always keep an eye out for legislation. We've all heard about, and we'll talk again today about the Families First Coronavirus Response Act. Of course, our governor's executive orders that are constantly coming at us, constantly changing. It's important to keep up on those. You want to be on the lookout for local ordinances from your local health department. Fortunately, here in Kalamazoo County, we haven't had a lot of those, if any. I know a lot of other counties throughout the state of Michigan have had orders along the way and ordinances.
Sorry about that, folks. Hopefully Leigh's able to come back in and join us. Just give us a minute.
I'm sorry, technology, it works when it works and it doesn't when it doesn't.
That's exactly right. No worries.
Okay. Well, let's jump right into the most recent executive orders because this is going to be most important and something that's probably new since we last had any education on the subject. These executive orders were issued on Friday, September 25th. So we now have Executive Order 2020-183 and 184. 183 was an amendment to the Safe Start order. So the governor originally had her stay home order. Now she's got the Safe Start order and she continues to amend it. For anybody that's out there that happens to operate a theater, movie theater, a performance venue, a arcade, a bowling center, or so on, an indoor trampoline park, I'm sure you're all thrilled because you can now reopen effective October 9th. There are also increases to the indoor gathering and outdoor gathering limits. So we can now have non-residential indoor gatherings up to 20 people per 1,000 square feet or 20% of the seating capacity with a maximum of 500. And outdoor gatherings can go up to 30 people per square feet, 1,000 square feet or 30% of seating capacity with a max of 1,000. If anyone on this webinar is in region 6 or 8, your limits are a little bit higher. But here in Kalamazoo County and in Southwest Michigan, we can go to the limits that are in 183. What I think is noteworthy for employers is that these limits, while in the last Safe Start order, it made it clear that they apply to workplace trainings, this one does not. So now it says that they do not apply to, quote, incidental gatherings of persons in the workplace, but they do apply to social gatherings and organized events. So I think what that language means is they still probably do apply to workplace trainings and any organized event that you have in the workplace. So you're going to want to limit your inside training to the 20 people per 1,000 square feet. Again, region 6 and 8 still have that indication that remote work should be performed. And here in these regions down in southern Michigan, both on the east and west side of the state, we still have to require remote work to be performed by those who can perform it. I have gotten this question a lot. How do we know who really has to perform remote work, and who we can have come into our workplace? My response generally is it's similar to the ADA analysis of what are the essential functions of the job? What is the person really there to do? If those functions have to be performed in person in the workplace, then I think you can require them to come in person into the workplace. However, if the essential functions of the job truly can be performed remotely, then I think you do need to have employees performing remote work still at this point, according to the governor's executive orders. Of course, when you're bringing people back into the workplace and deciding who should be back and who shouldn't, you just want to make sure you're not discriminating on the basis of a protected class. So for a while there was a concern about bringing older employees back into the workplace because they were more susceptible to COVID complications or high risk for COVID. We can't do that. We can't say older workers, you can't come back to work, but younger workers you can, because of course that would be age discrimination. So you don't want to make any decisions based on protected categories. If you have somebody who has a medical condition and they need an accommodation, we're talking about disability related decisions, that's a different discussion, and we're going to get to that in a little bit. There are other things to think about when you're talking about having people back in your workplace and bringing them back. You can think about other ways to limit the number of people. My office, for example, has limitations on how many people can be here at any one time. So there are possibilities of changing people's schedules and staggering their shifts. We've also had a lot of discussions with employers along the way about reducing the work week and shortening somebody's schedule down to part-time from full-time. Typically speaking, especially for non-exempt employees, that's easy to do. You're only paying them for the time they actually work, so you can adjust their schedule as needed. For salaried exempt employees, it's a little bit harder. You can do that. It needs to be on a prospective basis going forward for some substantial length of time. What you don't want is to adjust somebody's salary up and down depending on how much work you have and how often they're working, because then they look like they're non-exempt people. And of course, that's not what you want to do. You don't want to lose the exemption. So if you're going to reduce someone's salary and reduce their technical schedule, then you need to do it prospectively for as long as you can, at least a couple months of time, if possible. Okay, so that's Executive Order 183. Now we're talking about 2020-184, also issued on Friday, the 25th. And this amended the Workplace Safeguards Order. So many of you know there's been about 5 different versions, if not more, of this Workplace Safeguards Order. Many of them are very similar. This one is very similar to many in the past, so we'll just go through it again and make sure you know what's required. It still requires you to have this COVID-19 preparedness and response plan that most of you have already. You have to make sure you have a supervisor that's on site at all times to monitor compliance with your COVID-related plans and your rules. You have to make sure you're training your workers on COVID-19. Now, I think if you roll out your preparedness and response plan to your employees and you walk them through it and you explain to them what it says and you talk about COVID, and most preparedness and response plans do explain what the disease is and how it's transmitted, that should be enough to fulfill the training requirement. You still have to post your signs encouraging regular hand washing, disinfecting, and telling people to stay home when they're sick. You also still have to provide face coverings, and you have to actually require them to be worn whenever employees aren't consistently at least 6 feet apart. And of course, whenever they're in shared spaces such as restrooms and hallways. I know this is a tough one, and I know a lot of different people have different views on face coverings, and it's hard to enforce at times, but it is an important rule. And it really comes into play mostly if you do end up having somebody who tests positive for COVID or who has the symptoms of COVID. If you've been really good about the 6 foot of distance rule and requiring people to wear masks, it will have less of an impact on the rest of your workforce if you have a positive case. You won't have to send as many other people home, basically, is what it really comes down to. If you've been making sure that this rule is followed. So it is very important, and it's hard. And I know people want to fight back on it, but we got to do the best we can as employers to enforce the rules. And you should discipline, by the way, if you need to, if people aren't following your rules. Okay, so you still, of course, have to try to increase your facility cleaning and disinfecting, give employees additional cleaning and disinfecting supplies, and restrict business travel to essential travel only. The one thing this order does not require that the others did is that you suspend non-essential visitors. So it appears now that the governor is allowing you to have what's quote unquote non-essential for a visitor in your workplace if you need to. 184 also still requires you to do the daily screening protocol. And we're going to talk a little bit more in detail about what I think that screening protocol should look like. But it's important that you still do it. And you have to have this questionnaire every day. You have to ask them about symptoms, and you have to ask them about suspected or confirmed exposure to someone with possible COVID, not just positive COVID, but possible COVID. And again, we'll get into that in a little bit more detail in a minute. You also have to allow employees with confirmed or suspected COVID to stay home. This is how it's been for a while now, for the period set forth in the governor's other order. The most current version of that one is 172, and we'll go through that as well, how long you have somebody stay home. And that order incorporates, as does this 184, the CDC guidelines. If an employee tests positive, you still have to notify the local health department immediately. You also have to identify whoever's been in close contact with them and notify them within 24 hours. Now, the close contact rule has been clarified in the last month or so as to mean less than 6 feet of distance for more than 15 minutes or 15 minutes or more within the 48 hours before the person tests positive or before they show symptoms. So if you have someone who tests positive, you're going to have to determine with your supervisors or managers who else could have been within 6 feet of that person for 15 minutes or more within the 48 hours before this time. I think you've heard probably over and over again, it's very important not to breach the confidentiality of the person who tested positive. So the ADA would prohibit you from disclosing the identity of the person who tested positive or the person who has symptoms even. You can tell your supervisors and managers because they have a legitimate need to know if you're really trying to figure out who the close contacts are, but you can't put a message out there to everyone saying, okay, John Doe has tested positive. Who was within 6 feet of that person for 15 minutes or more in the last 2 days? Because that would violate John Doe's ADA privacy rights. So it's tough. It's tough to figure out who the close contacts were. You have to do the best you can. You can look at schedules. You can look at working environments and try to figure it out. But this kind of goes back to why I was saying the 6 feet of distance rule makes a really big deal, because this is where it comes into play. And then, of course, you have to do additional deep cleaning of the person's work area if they test positive. So let's talk about the daily screening protocol. And you'll see my note at the top. This is subject to change. And I should probably preface that everything I'm saying is subject to change. So if in 2 weeks from now the rules change and you say, but I went to this webinar and Leigh Schultz told me this is the rule, please don't rely on me for that. All right. So I think these are the two important questions for the daily screening protocol. I know there are others that people ask, but this is what I think you need to ask. Number one, since you last reported to work, have you had any one of the following symptoms? And this is the governor's language. This comes from EO 2020-172. Any one of the following symptoms not explained by a known medical or physical condition. That's going to be the fever of 100.4 or above, uncontrolled cough, or shortness of breath. Or at least two of the following not explained by a known medical or physical condition. And those are the ones that the governor lists as the secondary symptoms. If the person answers yes to either one of those, they have to go home. We'll talk about for how long. The second question is, since you last reported to work, have you had close contact with anyone who is displaying the symptoms listed above or who has tested positive for COVID-19? My parentheses are by accident, but close contact should be defined for this, daily screening protocol so people understand that it means 6 feet or less for 15 minutes or more. It also means if the person directly touched you, you shared food utensils with the person, or they coughed or sneezed directly. Those are the only questions I think you really need to ask. I know a lot of employers still ask, have you traveled within the last 14 days? You're certainly welcome to ask that. There's nothing that says you can't. What I struggle with is if they answer yes, are you going to automatically exclude them from the workplace? And does it matter where they traveled, how they traveled, who they went with, what they did while they were there? And is it really any different than asking somebody what you did last weekend? Did you go to a crowded restaurant? Did you go to a crowded grocery store? Did you go to a party? I think there's a lot of things you could ask about that. You could end up excluding someone from the workplace if you wanted to, but you're not required to. There's no order, federal, state, or local order here in West Michigan that would require you to ask about travel. So I don't think you need to, and I think it could just end up causing you to send more people home than you really want. Now let's talk about how long people have to stay home. So again, the current executive order, 2020-172, which incorporates the current CDC guidelines, they say, number one, if somebody has symptoms, whether they tested positive or didn't even get a test, if they have symptoms, one of the primary ones we just talked about, or at least two of the secondary ones, then they have to stay home for 10 days until the symptom from when the symptoms first appeared for at least a period of 10 days. They also, within that 10-day period, have to go at least 24 hours fever-free without medication, and the other symptoms have to have improved. That's the baseline rule. So most people, it's going to be 10 days. Now, there is an exception to that rule, according to the CDC. If they get 2 negative COVID tests in a row, at least 24 hours apart, they can come back sooner than the 10 days. This is for someone who has symptoms, whether they tested positive or not. Then you go to somebody who has no symptoms, but they test positive. It's still going to be the 10 days. 10 days from the time that they had the swab that yielded the positive result. But the CDC also says with this type of person, they can come back sooner than that if they get 2 negative tests in a row, at least 24 hours apart. Now, if they end up developing symptoms, they still have to wait until at least they're 24 hours fever-free, other symptoms have improved, and 10 days from when the symptoms first appeared. So don't forget, sometimes these kind of overlap each other and you have to flip-flop from one to the other. Then you get to the person who has no symptoms, but they've had close contact with someone with symptoms or someone who tested positive. And the close contact occurred within 48 hours before that person's symptoms appeared, before they tested positive. Those people have to stay home for a full 14 days since the last close contact, or according to the governor, until the individual displaying the symptoms receives a negative COVID test. So it could be that the person who actually has COVID gets to come back sooner than the person who had close contact with that person. And it can seem a little bit odd, but that's the rule. The executive order does make it clear that these rules about staying home solely due to close contact with a symptomatic individual don't apply to the following groups of people. Now, if a healthcare worker actually gets COVID and has symptoms or has a positive test, they do have to stay home for the 10 days, the 10-day period, but they don't have to just solely due to close contact with a symptomatic individual. And that makes sense because healthcare workers probably have close contact with those folks on a regular basis. These rules about staying home solely due to close contact with a symptomatic individual also do not apply, according to the CDC, to somebody who has already had COVID within the last 3 months, as long as their symptoms don't develop again. So if you get an employee who you think is starting to abuse the system, and I have a lot of clients who have had this, they're calling in every other week now saying they think they have COVID and they have to stay home, or they have symptoms and they have to stay home. If at some point they do in fact test positive for COVID, you don't have to keep excusing them every time they call back in. Now, if they call back in and say they have symptoms again, you technically probably should, but I think you can ask for documentation of those symptoms at that point to ensure that they're not falsifying their reasons for leave. But according to the CDC, if they've had COVID within the last 3 months, they should be okay. They shouldn't be able to get it again, at least as far as they know right now, and they shouldn't have to go home. So that's the end of it on how long people have to stay home. Now let's talk about what happens if they do stay home, or what happens if they refuse to come to work. So we've talked, I'm sure, at length in other webinars and in other information you've read, you've heard at length about the Families First Coronavirus Response Act. It applies only to employers who have less than 500 employees. It's effective as of right now only through the end of the year. There's the 2 types of leave: emergency paid sick leave and emergency family medical leave. And you should be able to get tax credits for this type of paid leave, unless perhaps you're not an employer who pays taxes or you're a public sector employer. You probably can't get the tax credits. And Gary can better answer those questions than I can. He's expert on the tax. Just as a refresher, again, emergency paid sick leave, there's a number of reasons someone can qualify. What's happening most often is number 1, the employee has to stay home because they're subject to, in this case, a state order that requires them to quarantine or isolate due to COVID-19. And that, again, would be what we just talked about, Executive Order 2020-172, which gives the time period that a person has to stay home. That would be a state order of quarantine or isolation that would qualify someone for paid leave under the Emergency Paid Sick Leave Act for reason number 1. The person could potentially also qualify if they have symptoms and they're seeking a COVID diagnosis for reason number 3. But even if they're not seeking the diagnosis, if they have the symptoms, as of right now, they'd qualify under number 1. Number 2 comes into play when somebody has been told by a doctor that they need to self-quarantine, and typically this is when someone's at high risk for COVID. So if you have employees who say, my doctor tells me because of my underlying health condition that I really shouldn't be coming into the office right now or the workplace right now, I need a leave, you'd have to look at that under number 2. And we'll talk about other laws that are going to apply to that as well. Number 4 and number 5 are the caring for others. Of course, there's the major issue of childcare right now with schools being closed and schools being all over the place on what they're doing. And number 4 is caring for someone who's got symptoms or who's been told to self-quarantine. If somebody qualifies for emergency paid sick leave, they get up to 80 hours of leave or the equivalent of 2 weeks of their regular schedule. So if it's a part-time person who normally works 30 hours a week, they're going to qualify for up to 60 hours of emergency paid sick leave. The amount of pay depends on the reason. Reasons number 1 through 3, it's 100% of pay for the up to 80 hours or a max of $511 per day. And reasons 4 and 5 is 2/3 pay, up to $200 a day. There is no eligibility criteria or waiting period. This is for brand new people. Then you flip into the emergency FMLA, and that is only for the one sole reason of childcare. So if somebody has a son or daughter whose school or place of care is closed or whose regular daycare provider is unavailable due to COVID, they qualify for emergency FMLA. And all that matters is that they worked for you for 30 days. So the traditional FMLA analysis doesn't apply. We don't have to make sure they've worked 1,250 hours, and we don't have to make sure they've been there for a year. It's just the 30 days. And they would get the full 12 work weeks of leave. Now, you always want to ask yourself, okay, has this person taken any other FMLA in the last 12 months, assuming you use a rolling calendar for a rolling 12-month period for your FMLA. If you do that, you still need to look back and say, have they used FMLA for any other reason in the last 12 months? And if they have, that counts towards their total leave entitlement. When it comes to intermittent leave, for either emergency FMLA or emergency paid sick leave for childcare, you can allow it, but it has to be with your agreement. And oftentimes what I'm telling my clients is that it's probably in your best interest to allow it because at least you're getting some productivity out of the person. So if someone comes to you and says, I really can't find any other childcare for my kids on Tuesdays, but every other day I can come to work. It's probably in your best interest to say yes to that because then at least you get them coming in every other day. But that's up to you to decide. So you can see how you feel about that. One question I'm getting a lot on the school issue is, what do we do when, the schools are technically closed, but somebody may have the option. Somebody may be able to send them in person and they're choosing to keep them home. I think that the regulations have been, or the Q&A from the Department of Labor has made it clear that if there is an option, they don't qualify for leave. If they have the option of sending their kids in person and they're choosing to leave them at home or keep them at home, they're not going to qualify for this leave. But many school districts have a hybrid method right now where it's a couple of days a week. So they may have an option a couple of days a week and not have an option the rest of the days of the week. And in that case, again, intermittent may be the right option for you to consider at that point. There are limitations on the documentation you can get for these leaves, but when it comes to the childcare leave, I do think that you need to know enough to know what those options are. You need to know what school district the kids go to and what plan is in place in that particular district and for how long, because a lot of these plans are changing regularly. So you need to be aware of and knowledgeable about exactly what the plan is in that district, when it's supposed to change, if it's supposed to change, so that you can know how much leave your employee may be entitled to. This is again 2/3 pay, up to $200 a day. And it's supposed to work interchangeably or concurrently with emergency paid sick leave, although the way it's written, technically, the employee could choose to use emergency paid sick leave for something else. they could choose to hold that back. So they could say, I want to take the first 2 weeks of emergency FMLA unpaid, and I'm going to hold back my emergency paid sick leave just in case I get sick later on or a family member gets sick. They could do that. Or they can use the other type of paid time off that you otherwise provide. But I would say most employees that I'm aware of are using these concurrently. So the first 2 weeks of this 12-week period is going to be paid under the Emergency Paid Sick Leave Act, and then the remainder is going to be paid as emergency FMLA. There is a small business exemption. Those of you with less than 50 employees probably are aware of this. It only applies to childcare leave. No other form of leave under the Families First Coronavirus Response Act can you claim an exemption from. But if you have less than 50 employees, you may be able to exempt employees from childcare leave. Now, what the statute says is that you'd have to show that it would jeopardize the viability of your business as a going concern. That's a financial phrase that has some sort of meaning in the financial world. But what the Department of Labor has said is there's 3 ways of showing that. Number one, if you can show that your expenses and financial obligations would exceed your available revenues if this person went on leave or these people went on leave, and it would actually cause your business to essentially cease operating, you can show it that way. What's more likely is that you may be able to show it under number 2 or 3, which is that the particular employee or employees requesting the leave have such specialized skills and knowledge and responsibilities that allowing them to take a 12-week leave would truly cause a substantial risk to your operational capabilities or your financial health. And number 3 is similar in that you can say, you could show potentially that there's not any other workers, sufficient other workers available to perform the services that this person performs or people perform, and that those services are necessary for your business to operate at a minimal capacity. So those will come into play more often when you have somebody who has skills and responsibilities that you really can't go without for 12 weeks and you don't have anybody else to do them while they're gone. You don't file a formal application, by the way, with the Department of Labor to get this exemption. It's just something you're going to have to show if you're challenged. There's also the healthcare provider and first responder exemptions. What's very important for this presentation is that the healthcare provider definition has changed. There was a lawsuit in New York in federal court where this definition was challenged because originally the Department of Labor was saying anybody who works for a healthcare organization basically can be excluded. The employer does not have to provide them with leave. And that was so broad that it was including even places where any healthcare topics are taught. So universities, colleges, and other places, they've narrowed that exemption or that exclusion. And now you really have to be able to show that the person's actually providing care, providing patient care, or at least providing a service that assists patient care. So diagnostic services, preventative services, treatment services, and other services that are integrated with and necessary to the provision of patient care. So I have healthcare clients that I represent who have had to go back and now effective 9/16 start providing leave under the Families First Act that they didn't before. Emergency responders are also excluded. So let's say you're not covered by the Family First Coronavirus Response Act because you're bigger than 500, or your people have already exhausted it, or maybe they're just not eligible because the reason they're asking for time off doesn't fall within one of the categories. Where else do you have to look? Well, of course, we have the Paid Medical Leave Act in Michigan, 40 hours of paid time off that people can probably use for a lot of reasons that could be covered in this pandemic, to care for someone else, to care for themselves, and so on. And in fact, the governor's order, Executive Order 2020-172, the one about how long people have to stay home, does say that when people have to stay home for those periods of time, it should be treated as paid medical leave under the Paid Medical Leave Act. So don't forget about that. Then you have regular FMLA. Now, more often than not, COVID-19 related issues are not going to qualify for regular FMLA. They may if the person is so sick that they're truly incapacitated. But if it's somebody who's saying, I am at high risk because of an underlying health condition, so my doctor's telling me not to come into the workplace, or my child is at high risk, and so I would like to not have to come into the workplace, that's not typically going to qualify for regular FMLA because the employee or the child are not truly incapacitated. This person just doesn't want to have to come into the workplace. So it's probably not going to qualify for regular FMLA. It could, it just depends on the facts and circumstances of the case. What's more often than not going to come into play is the ADA for the underlying health condition issue. If I'm at high risk because I have COPD and I'm telling you that my doctor's telling me I need to stay home and not leave my home, I'm looking for an accommodation under the ADA. And you are going to have to go through the interactive process, and you are going to have to get the medical documentation to support the request. And you are going to have to figure out what they're really asking for. Because I've heard about requests where people say, well, I want to have a leave of absence or work from home until COVID is over. Well, what does that mean until COVID is over? Or until there's a vaccine, or until everybody takes the vaccine? I mean, there are a lot of strange things that people are asking for right now. Don't forget that you never have to provide an indefinite leave of absence under the ADA. Even the EEOC says that would be an undue hardship, and it's not reasonable. So you still have to go through the interactive process. You have to determine whether or not, first of all, they have a true need for the accommodation. And second of all, whether or not what they're asking for is reasonable, or would it cause you an undue hardship. And as part of that process, don't forget that you're allowed to suggest other accommodations other than a leave. So we've had lots of discussions with folks over the last few months that, okay, well, I'd like to not have to come into work. Okay, I understand that, but is there anything else we can do that would allow you to come into work? What if we put an extra plexiglass shield around your workstation? What if we put you in a different part of the facility where you're much farther away from other people? You know, there are other things to consider than automatically looking at a leave of absence. And then, of course, if you have leave under your policies that someone might qualify for, you're going to have to look at those as well. Okay, I'm going to flip it over to Gary now, and he's going to talk about the exciting topic of taxes.
All right. Pleased to meet you. I'm a real live tax lawyer, so you can check that off your bucket list now. I was going to cover primarily the payroll tax deferral that was announced through an executive order by President Trump when the House and Senate were at loggerheads about additional stimulus for the economy. Trump's issued an executive order that basically says anyone making $4,000 or less on a biweekly pay period or the equivalent can have their Social Security tax, that's the 6.2% tax with the overall wage limit of $137,000, deferred for the last 4 months of 2021, and then the deferred tax would be paid in the first 4 months of 2021. But the plan was to have legislation implemented that would permanently eliminate the tax for that period, not permanently eliminate the tax forever. And Leigh, if you can hit the next slide from time to time, that would be good. So the ability to do this rests with the Department of Treasury. So it was an order to Secretary of the Treasury Mnuchin to use his authority to postpone due dates when there's an emergency declared. Now, the normal types of emergency are hurricane, flood, fire, those kinds of things. But the COVID has been declared as a national emergency, so the authority to do this exists, but it only postpones the due dates for the withholding of the tax from the employee's portion of wages only until next year. So that's the basic outline of the program, but there's not much guidance. And the IRS waited until about 2 days before September 1st, when the program was supposed to start, to issue notice 2020-65, which is only 2.5 pages double spaced and doesn't say much. They have a proposed change to 941, and I can take you through how that's supposed to work, because IRS issued a revised Form 941. Most of the guidance is kind of oral from the IRS, so it's not binding. Importantly, last week they talked to a group of payroll tax executives, and that session was recorded and then widely reported on. The important thing that wasn't clear from any of the guidance is that participation is not mandatory for employers. It's entirely voluntary, and there's no penalty if you fail to participate. So what are the aspects? The employee has to make $4,000 or less. Sorry, I'm getting a phone call. For each biweekly period or an equivalent period. So, for example, if you pay monthly, it's like $8,167. Anything less than that or over that does not qualify. You have to do this on a payroll by payroll period. So it's kind of labor intensive to determine whether a particular worker who's close to the limit is going to be over the limit. For example, they might have overtime pay. Employees might want to say, well, defer my overtime pay because I'd prefer to get the 6.2% deferral if possible and get my overtime next year. Leigh can address whether that's legal or even possible. That's all right.
Sorry.
Taxes, the deferral is only for the employee portion of the Social Security tax and does not apply to self-employed workers. So if the employer participates, we get to the following year, and now they're supposed to repay the tax. Now we're on the next slide, if we can. Ratably over that 4-month period. Well, what's not clear from any of the written guidance is what happens if the employee quits or retires, and how do you determine it ratably? Is it based on their compensation, or do you have perhaps, what would it be, $2,000, $3,000 that has been deferred over the last 4 months? Do you divide that by the 4 months and recoup it ratably? And there's no real guidance on whether you do it based on the employee's compensation or anticipated compensation or time period. It's likely the time period. The important part, though, and this came out just last week, is what happens if the employee quits or retires. And the IRS told the payroll tax executives the following: it's the employer who's getting the benefit of the deferral, that not being obligated to withhold the tax. But if they paid the wages in the last 4 months of the year, that's a tax that they should have withheld. All that happened is that the due date for the withholding has been postponed. So they're still liable for the tax. Well, if the employee is quit, why don't you hit the next slide? It might be on the next slide. If the employee is quit or retired in the meantime, the employer is still liable for the tax that was deferred, but they're unable to collect it from the employee who no longer works there. So there was a very vague statement that says, if necessary, the employer may make arrangements to otherwise collect the total taxes from the employee. That could be a promissory note from the employee to pay the tax, or some undertaking, or perhaps an agreement from the employee that the employer could take it from accrued vacation pay that might be payable when an employee quits or otherwise retires. But again, Leigh would have to address how an employer could do that legally under state law. So anyway, the notice only postponed the obligation, not the liability, and the liability is on the employers. So, and the other part is if the employer, the company, is unable to pay, this is the type of tax where there's officer liability for the failure to withhold and pay over the tax. So if you're not the owner of the company, but you're an officer, president, treasurer, assistant treasurer, you've got the possibility that you're going to be personally liable if the company can't come up with the deferred tax. So kind of a risk. So what's been happening? Well, most employers that I found are not participating in this program. The Wall Street Journal reported these large companies, Wells Fargo, JP Morgan Chase, they're listed there, are not participating. Detroit Public Schools is not participating, and none of the clients that I've counseled are participating in this program. There were questions about whether you could pick and choose among employees, allow some employees to participate and not others. I think it's possible because it's entirely voluntary, but it's a risk that you're undertaking that if something happens to the employee, you're going to be liable for the tax. The notion was there would be legislation that would permanently eliminate the deferred tax. I don't see any legislation happening by the end of the year, and who knows what next year brings. And by next year, it would be, you've already got the obligation to start repaying the tax. So I'm not quite sure how they could tailor the legislation, and even if it's passed, I'm not sure how they could tailor it so that only people who participate in the program would have the deferred tax forgiven. It would seem to me it would have to apply to all workers. And so workers who had paid the tax during these 4 months could probably somehow apply for a refund, but there wouldn't be any guidance on that. Some commentators were worried that you'd have a class action lawsuit against the employer because they were effectively prepaying the tax from the employee. It's not really due until next year. I haven't seen a class action yet, but class actions are expensive and you don't want to be involved in that. But there does not seem to be a right on the part of the employee to require the employer to participate in this. So it's entirely voluntary if you do want to participate, and I'd be interested to hear if any of you are participating in it. I thought I mentioned briefly the Biden proposal as well in the event that he's elected. Right now, the Social Security tax applies up to a wage base of, I think it's $137,700 indexed for inflation. If a worker was making over $400,000 on wages, the Biden proposal would start the Social Security tax, both the 6.2% due from the employee as well as the 6.2% due from the employer on wages above that amount. This will lead to a lot of tax planning strategies where employers and employees will try to limit their wages to $400,000 and come up with other ways to obtain remuneration. Most of the time at that level, especially for smaller companies, it's an owner situation where the company's doing well, and an S corporation would be a better strategy. Especially if you're participating, then you're not subject to the net investment income tax of 3.8%. So I hope I went through that very quickly for you, and I'm happy to respond to any questions people might have.
I'll just respond really quick, Gary, on the couple things you mentioned in my name. On the idea that an employee could potentially waive or defer their overtime pay, that's not going to fly. The Fair Labor Standards Act, as most people know, is a work week by work week statute. So what's earned in a certain work week has to be paid appropriately. In our state of Michigan statute, the Payment of Wages and Benefits Act governs when the pay has to be actually received by the employee. So we wouldn't be able to get an agreement by the employee to defer that, or certainly not waive it if they're entitled to it. If you ever have a situation where you have to go after an employee for anything after they've quit or retired, you know how difficult that may be. So if the idea is that you might have to try to chase them down for the taxes that the employer ends up responsible for because they've been deferred and the person quits, the likelihood of you getting those from the employee is slim to none, as we all know when we have to chase employees for things they owe. So just keep that in mind. All right, well, Carrie, we're happy to answer whatever questions came in throughout the presentation.
Perfect. I have one question only, and this will be directed to you, Leigh. Can the employee return sooner if they receive a medical diagnosis or direction from their physician? And if so, do we require them to provide documentation?
So I think that goes to the question of whether their symptoms can be explained by a known medical condition. And the governor's executive order 2020-172 talks about if the symptoms cannot be explained by a known medical condition, then they need to stay home. But if they have a known medical condition or diagnosis that's not COVID that's causing the symptoms, and they have proof of that from a physician, I think you could allow them to come back sooner. Yeah, I mean, it would basically be saying it's not COVID. I think most doctors out there right now are telling people to go get a COVID test if they have the symptoms. But again, if you have a medical condition where you get, a severe cough every year, or you have it due to something else, or shortness of breath is caused by some other asthma or COPD or whatever it may be, yes, they could stay at the workplace or come back sooner.
Okay, perfect. That was the only question. And appreciate both of you, Leigh and Gary, for helping us stay compliant, certainly when things continue to be changing, and we are always updating our policies. So we have activity numbers. I'm going to read off very quickly to all of you that are still on the call. Those that came off the call early, we will send these to you via email. The SHRM credit number is 20, N as in Nancy, 296. So that's 20 NN 296. And then the HRCI number is 535215. Again, that's HRCI 535215. And then lastly, we have our fun giveaway, and I'm going to turn the table over to my colleague in the St. Joe area, Ted Chase, and he is going to announce our winner.
Well, thank you, Carrie. Today we are going to give away one fantastic Nolte Yeti cup, and this is especially designed. Oh, it'll also come with a $25 Big B gift card, so that you can put whatever pumpkin spice nonsense you would like in your cup. So, Carrie, if you will do me a favor, will you pick a number between 1 and 100, and we'll figure out who our winner is today.
All right, you know what? I'm going to split it down the middle. I'm going with lucky number 50.
Lucky number 50 is Edith from Safari Circuit. So congratulations. And one of your favorite Nolte team members will make sure you get your coffee mug and your gift certificate.
Awesome. Congratulations.
Thank you guys so much for coming today. Thanks again, Leigh and Gary, and we hope you guys learned everything you needed to know. And if not, please reach out to one of the Nolte teammates, and we'll be happy to send you in the right direction.